The community in the north had a highly developed system of Muslim law of crime with different schools, though the Maliki was the most dominant. Paganism was also practiced with its unique paganism criminal law. The Lagos colony had the modern English common law, which was introduced by Ordinance No. 3 of 1863. The various political evolutions, which went on in the various protectorates and colonies, also led to the development of criminal law in Nigeria. In 1904, Lord Lugard, the governor of the Northern Protectorate, introduced by proclamation a criminal code which incidentally was made applicable to the whole of Nigeria in 1916 after the famous amalgamation in 1914. Following intense advocacy by the Northerners, the Penal Code Law, number 18 of the Northern region, was introduced in that region. That exercise also restricted the Criminal Code of 1916 to apply only in the southern part of Nigeria. The Penal Code was tailored against the background of the Code of Sudan, which itself had its origin from the Indian Penal Code of 1860. Elsewhere in Nigeria, and particularly in some parts of the south, there was also the application of customary criminal law. At the moment, Nigeria operates a dual code system because of the applicability of the Criminal Code and the Penal Code. Furthermore, for effective administration of criminal law in our courts, the law of criminal procedure was codified as the Criminal Procedure Code of 1960. At the 1958 Constitutional Conference, it was decided that customary criminal law be abolished in Nigeria, and that decision was articulated in the 1959 Bill of Rights, developed by Nigerians and submitted to the colonial government in London. The British Home Government approved the request, and the same was incorporated in Section 22, subsection 10 of the repealed 1963 Republican Constitution. That section of the Constitution read, "No person shall be convicted of a criminal offence unless that offence is defined, and the penalty therefore is prescribed in a written law." The foregoing was the basis for the court's decision in the case of Ayoko. At the moment, Nigeria operates a dual code system because of the applicability of the Criminal Code and the Penal Code. Furthermore, for effective administration of criminal law in our courts, the law of criminal procedure was codified as Criminal Procedure Code of 1960 for introduction to Nigeria criminal law. 3.3 Purpose of criminal law. Criminal law exists, and it is studied in order to ensure true knowledge of the law by the people, to be familiar with the nature of crime, the proceedings to be adopted in prosecution, and the punishments which the law has put in place against the offenders. For example, the objects of criminal law, according to the Wolfenden Committee on Homosexual Offences and Protection, are A. to preserve public order and decency, B. to protect the citizens from what is offensive and injurious, and C. to provide sufficient safeguards against the exploitation and corruption of the more vulnerable members of the society. 3.4. The nature of crime. In order to understand the nature of crime, one has to look at the legal consequences which may follow it. For example, if the wrongful act or omission is capable of being followed by what is called criminal proceedings, that means it is regarded as a crime, otherwise called an offence. If it is capable of being followed by civil proceedings, that means it is regarded as a civil wrong. Crime or criminal wrong on the one hand and civil wrong on the other hand could be distinguished from each other. The true distinction between a crime and a civil wrong lies not in the nature of the wrongful act, but in the nature of the proceedings and in the legal consequences that may follow. 4.0 Conclusion. In this unit, you have been exposed to the history and sources of criminal laws in Nigeria. It has also sufficiently demonstrated that nobody can be punished under the laws in Nigeria except the law is written and punishment defined. 5.0 Summary. This unit has revealed the facts that Nigerian criminal law developed from English common law. The sources of Nigerian criminal law are technical statutes on criminal matters, as well as the Criminal Code and the Penal Code. And that case law is a secondary source. There was in existence unwritten and indigenous laws in Nigeria before the advent of British rule. The criminal law is instituted in order to regulate the conduct of the citizens. It is the nature of proceedings and the legal consequences which follow particular conduct or omission which characterize the nature of crime. 70 references and further reading. Okonkwo and Naish, 1990, Criminal Law in Nigeria. Ibadan Spectrum Law Publishing. Caribe White, AG, 1993. History and Sources of Nigerian Criminal Law. Ibadan Spectrum Law Publishing. Williams G, 1982. Learning the Law. London Stevens and Sons. Unit 2. The Definition of Crime. This unit will define crime to enable students to have a good understanding of the concept. In defining crime, 3 approaches to wit, the juristic, judicial and the statutory we shall adopt. An attempt would also be made to distinguish crime from sin or immorality. Contents. Introduction to Nigeria Criminal Law. 1.0 Introduction. 2.0 Objectives. 3.0 Main Content. 3.1 Understanding definitions of crime. 3.2 Juristic approach to the definition of crime. 3.3 Judicial approach to the definition of crime. 3.4 Statutory approach to the definition of crime. 3.5 Crime distinguished from sin. 4.0 Conclusion. 5.0 Summary. 6.0 Assignment. 7.0 References and further reading. 1.0 Introduction. The conduct of the people in any organized society must be regulated in order to ensure stability and social harmony. 3.0 Main Content. 3.1 Understanding definitions of crime. There have been problems in the definition of crime and the consistent application of the components of such definition in tailoring the specific offences or crime, that is, the application of the definitions in the formulation of criminalization policy. Introduction to Nigeria Criminal Law. Though criminal law has been in operation in human communities for several centuries, yet lawyers have so far never agreed on any satisfactory definition of the word crime. But lawyers cannot afford not to conform to the demands made upon sociologists by Emile Durkheim, namely that the first step of the sociologist ought to be to define the things he treats, in order that his subject matter may be known. This is the first and most indispensable condition of all proofs and verification. The lawyers, despite their quibblings in definition, however, seem to have accepted by conduct an operational definition, but expressed and explained in the words of Terence Morris that crime is what society says is crime by establishing that an act is a violation of the criminal law. The Nigeria Criminal Code appears in effect to have adopted this approach when it defines an offence or a crime as an act or omission which renders the person doing the act or making the omission liable to punishment under the code or under any order in council, ordinance or law or statute. The definition, according to Professor Adeyemi, is an approach which is a shining example of mental inertia, wrapped up in the cloak of an a posteriori rationalization, just like any of the other individual definitions. Another definition that is being suggested is a definition based on an a priori approach. This approach can be usefully employed in streamlining the criminal law in a way that will better adapt it to the fulfillment of its role at the commencement of the criminal process as a selection instrument. The a priori approach is suggesting a definition of crime based on morality. It is opined that criminal law must reflect the values and aspirations of the community in which it operates. In reflecting the morality of that community, it is thereby reflecting its culture. However, the argument must not be understood to mean that courts should be enforcing morality per se. Rather, it means morality must be the basis.